you're a person who believes in freedom of speech, you have to fight and say what you feel and let the chips fall where they may.
You can't win.
You can't say whatever you want and then face some sort of repercussions for it later.
Nice fun, son. Nothing else in the world smells like that.
Kansas has possibly the weakest open records law in the country.
Retaliatory animus. Had it not been for that negative feeling towards speech, they would have not done that.
You think you can still control my life? Control never yours to take.
Are you telling me that 200 men against your boy is a no-win situation for us?
Wishing you could see things once my way. When it all gets ripped away.
Smell of napalm in the morning.
I can't hide the pain it brings so far away. Sometimes it gets hard to breathe when it's thrown up in my face.
All right, guys, good evening. It's a little bit of dreaded accountability in the middle of the week. Dr. Justin Spees and Michael here with Lawrence Accountability. As you can see on the screen here, we had a Robert Walker Jr. PreTrial conference today, and I want to give a shout out over to Dick at Kansas Freedom News for having this video for us to be able to go over this evening. Yep. Doc, you watched it with us earlier today. What'd you think?
Well, I thought it was overall, it was great. It was great, and it gave us something to talk about here because
Definitely.
The county prosecutor there in Elk County, her name's Jill Gillett. She dropped the ball on some things that had some decisions made here in this case in Robert's favor.
Yep. So a lot of you guys out there may already be aware of the Elk County situation, and the reason Justin and I got involved down there was because of this case and seeing what was going on and seeing how things were being handled in court. You know, we heard from Dick over at Kansas Freedom News about this a while back and just kind of got involved. If you are not aware, Robert Walker was arrested, manhandled. I mean, you can see right there, one of the deputies threw him around and choked him a little bit. And then they decided to escalate charges on him, kind of like they do. But Doc, I think probably the best thing to do is just go ahead and dive into the video here and get it started. But any of you guys that aren't aware of this, there's a playlist on my channel. There's videos on Doc's channel, as well as Kansas Freedom News, that go over this entire case. And it's all out there. Take a look. And he's got trial coming up this next week. And some of those parameters of how that trial was going to go kind of got laid out in this pretrial hearing today.
Yeah, and it's important to point out there that arrest was an unlawful arrest because he wasn't doing anything wrong when he got arrested. He was exercising his First Amendment right and got arrested while doing that. So it was an unlawful arrest to begin with.
And I do think it's probably behoove us to right now to go ahead and mention that button, because the whole point of this was that Robert didn't want to give his name and his information to enter into the county courthouse. And through our work down there and through open record requests and badgering them, trying to get information from them, we found out that that security button on that courthouse was put there by a janitor in 2010. There's no ordinance or no law behind it. It was just a janitor that threw it up there, and they've been running with it ever since. So
Yep.
that's where you get your law violations from stuff that a janitor puts in place.
Yeah.
But let's go ahead and let this roll a little bit and just let you guys hear a little bit of how this started. And I think it's rolling here. Again, thanks, Dick, for doing this for us and getting this together today.
Number 2023 CR 29. I think Mr. Walker appears in the office of his attorney, Chris Pate. Jill Gillett appears as Elk County attorney. This matter comes before the court at this time for pretrial conference. Implicitly, the court's also going to need to decide at least two motions that have been filed by the defense. And counsel, I just became aware during this recess I took to join on another device that apparently there's been a new filing in the case of what appears to be a third amended complaint and information, though it is not labeled as such. I have it printed out. I don't know if I understand totally what the implications are of the amendments, but we will proceed further at this time. Regarding the first motion that the court is going to take up this morning, and that is the motion to dismiss or amend. Mr. Pate, if you just summarize for the record here, what are you seeking by this motion?
Well, Your Honor, the third amended complaint filed this morning at 9:31 resolves my motion to dismiss. The request was that count 3 be properly amended back to a misdemeanor battery on law enforcement. This amended complaint accomplishes that, so this motion is moved.
Well, Mr. Pate, I do not totally agree. Count 3, and the state has had multiple opportunities to clarify this point. Count 3, in the view of the court, does not properly charge battery on law enforcement.
Now, guys, I'm going to pause just for a second to give you a heads up of what's happening here. The judge right now is looking at the filing that Ms. Gillett did, the new amended complaint, and he's looking at it with a critical eye and trying to make sure that it meets all the requirements that have to be laid out in a complaint to achieve the different statuses of charging. And pay attention to what he does here. This was really interesting to me, and especially to watch a judge do it.
An officer. It charges battery. There's no allegation in the text of count 3 that identifies that this was a battery on a law enforcement officer. It uses the name of Deputy Amy Bliss, but the reality is the law enforcement officer is an element of this offense. That element is not charged in this particular document. And quite frankly, the amendment, if any, should be to a Class B battery, just based on the language of the charge. Do you disagree with that, Mr. Pate?
Well, Your Honor, actually, I think that is a proper analysis, and the focus of my motion was inexplicably between the first amended and the second amended complaint information. It was elevated from a misdemeanor battery law enforcement to a felony battery law enforcement. And that was the focus of the motion. But I do agree upon further review, the court is correct. It does not have the additional element of law enforcement in the actual text of the complaint. It has it in the title of the charge, but not in the text.
All right, let's stop here for a second. So this is the first error from Jill Gillett there. So in order for that charge to have been legitimate, she needed to write it up in a way that made it, meet that requirement. And the judge looked at that and said, well, this doesn't meet the requirement for battery on a law enforcement officer because it's not spelled out as clearly as it needs to be spelled out to indicate that this was actually a law enforcement officer. And it's also hilarious that the deputy's name is Amy Bliss, and Jill Gillett typed it up with a typo, A-N-Y, Any Bliss. And the
Right.
judge even said that. He's like, Any Bliss. It didn't even say who it is.
Right.
So there's Jill's first error there.
Yeah. Well, and it gets better. Let's continue on here. We got a little bit of loading. I do have a little bit of weather in the area, but we shouldn't see too much of this going on.
Despite your earlier pronouncement, Mr. Pate, the court's inclined to grant the motion to amend count 3 to reflect a charge of Class B misdemeanor battery based on the language of the charging document. And again, the state has had numerous opportunities to either enhance or clarify the language of their various charging documents. The court will have this case go to trial on what's actually being charged.
And stop
and
there for a
again,
second.
it'll be the court's ruling that count
you're
3.
And so there's another error on Gillett that the judge points out and slaps her down on, is that she had numerous chances to get this right. The court gave her numerous chances to do it. And it's just a reflection of how unprofessional she is, how incompetent she is, and just how downright lazy she is to have had all these opportunities to get this charge right, and just failed completely to do that in her job as the county prosecutor. It's inexplicable.
Yep. That's how she rolls, though.
Will go to the jury as Class B misdemeanor battery.
And not law enforcement, just battery. That's it.
Yep.
All right. Regarding your other motion to dismiss, Mr. Pate, again, summarize your position in regards to that motion.
Your Honor, we were last before the court on October 14th. At that time, I filed a motion for bill of particulars. The court granted my motion. The court ordered the state to file a bill of particulars 7 days from the date of that hearing, which would have been October 21st. No such bill of particulars was filed. So I just simply filed a motion to dismiss count 1 in line with the court's previous order. I don't even think I needed to file the motion necessarily because the court already made the order. However, I did, so the record was clear. It did come to my attention this morning, or actually last night at 6:53, it appears Ms. Gillett did file the bill of particulars. However, I'm asking the court to stick to its previous order, which was that needed to be filed by October 21st or the count gets dismissed. There was no request for extension of the deadline. I'm just asking the court to enforce its previous order and dismiss count 1.
Oh, you guys are going to love
Ms.
this.
Gillett, even if this court were to construe the 7 days that the court set forth in this case as 7 business days, you're significantly out of time. I know that you did file a bill of particulars, not just as to count 1, which was consistent with the court's order, but apparently in regards to all other charges of the information. So what is your response to Mr. Pate's motion to dismiss?
With all due respect to the court, I had a jury trial last week because I had jury trial set 2 weeks apart by the court on the master calendar. Therefore, I was in jury trial prep, and doing jury trial all last week. So I took time to sit down and do all the bill of particulars stuff, get it ready, and have it filed for today.
Can you stop here for a second, Michael?
Yeah, because I mean, when this happened earlier today, I was literally just yelling out, wah, wah, poor Jill.
And yeah, exactly, man. She's just crying about it, like every excuse in the book, instead of just taking fucking responsibility for it. But
exactly.
as I was listening to this live, I was sitting there thinking to myself, well, even if she was that damn busy, she could just file. Why didn't she just file an request to have an extension on it? Didn't mean it would be granted, but she didn't even think to do that. And so, oftentimes when we go to these commission meetings, the commissioners and shit will try to get back at us and say, "Are you guys attorneys?" Like we don't know what we're talking about. But even my non-attorney mind knew that, you know, this attorney could file that request for an extension,
Meet your
and
deadlines.
she didn't even do
Yeah.
that. She didn't even,
Nope.
and the judge will point that out to her. But it's just interesting to think that someone that, you know, is supposed to know the fucking law and be on top of their game, she can't even think to do that shit. But meanwhile, people that are just have been caught up in the fucking system can see this shit clearer than this
Well,
fucking bitch can.
and we discussed this earlier. Maybe she wouldn't be so busy if she wasn't prosecuting bullshit all the time.
Exactly. And the bullshit, there's a lot of bullshit, but some of the stuff is that she was even looking at prosecuting us for stuff down there that we didn't
Right.
even fucking do. She's and
Exactly.
one other thing, I may as well make this point now, but towards the end here, she's going to bring up this court security stuff. She during the hearing, she's gone out and hired a additional court security to be in the courtroom with her at all times. And when I heard that, I'm thinking it's like, oh, okay, so you have the time to go out and get yourself additional court security for no reason at all, mind you.
Yep.
But you don't have the time to meet the fucking deadline to submit this bill of particulars. And so basically, you know, the judge gave her at the last hearing, gave her that 7 days to file a bill of particulars on just the first count, which was disorderly conduct. It wasn't all the other counts, just
Right.
the one count. And the reason why that was ordered is because I believe is because Robert had just got this new attorney appointed, and so he had requested it so he could get caught up on it. And he also needs some other. There was other clarifying information along with it as well that was needed about that charge. And so it was ordered then by the judge, like if you don't have that within this deadline of 7 days, then the charge is going to be dismissed. And so the attorney, Robert's attorney, went ahead and submitted the request to have it dismissed. And he said, I don't even think I needed to submit it because the court had already
Right.
ruled it. And that's precisely what happened. That charge got fucking dropped because Jill dropped the fucking ball on it. It's just glorious how bad
Listen
she did
to
her job.
yeah. Just listen to how this plays out, guys. It's great.
What's calendars have been for me, I had jury trials back to back, and I've had jury trials 2 weeks apart more than once this year. So I got everything done as soon as I could, as soon as the jury trial was over, because I had other stuff that was also pressing that comes in while I'm in jury trial, such as child in need of care information, which has to be done in a very specific time limit as well. And seeing as how neither of my counties can afford to have extra assistants that can do all of this extra work, I do it myself.
All right, 2 points come to mind. First of all, you're only required to do a bill of particulars in regards to count one, not all counts. So I think that would have restricted the amount of time necessary to respond. And number two, wouldn't the proper procedure have been for you or your office to file a motion for extension of time prior to the expiration of the deadline, so that at least that was on file to request the court to extend the time that the court had originally allowed?
Judge Young, I understood that you wanted a bill of particulars for the entire complaint, and that's what I prepared, was the entire bill of particulars for every charge.
All right, well, that's inconsistent with the court's notes stemming from that hearing. I think the issue was, and the controversy was around the disorderly conduct charge in count one only. I don't recall that Mr. Pate had asked for a bill of particulars as to all counts, but really clarification as to count one. Quite frankly, I understand, Ms. Gillett.
This is kind of important, guys, because if you don't know what a bill of particulars is, this is something that a defense attorney can request when the prosecutor has gone so broad with the definitions and the descriptions of what's going on. And the bill of particulars is something that they can request through the court. It was ordered by Jill, by the court, to have Jill file it on count one to describe exactly how Robert had committed disorderly conduct. Now, the important part about a bill of particulars in court is the fact that that document locks the prosecutor into that argument. They can't stray from that and bring up other theories once that bill of particulars is filed. So, Justin, I'll give you just a second, but I wanted to explain that. And it's interesting that she filed that bill of particulars on all the counts, not just the first one. Now, I'm going to be curious if the judge is going to hold her to that bill of particulars on the other counts in trial, based on the fact that she filed it, not necessarily that he required it. Doc, what do you think on that?
Man, that's a great question. I hadn't even considered that. My guess is probably not, but I don't know, because since he only ordered it for the first, so for the first count, so I'm not sure. But that's a great fucking point and a great explanation of what it is as well.
Yeah. So when
Um,
I've had a bill of particulars ordered in mine, so it does lock them into that argument. It lets the defense plan their defense to the argument that they know is coming at them. Go ahead, Doc.
Yeah, so I guess even if it's not allowed or not allowed, she submitted that, right? So they have that in their possession now.
Right. Right.
Yeah.
Yeah.
I was going to point out, just the lack of self-awareness on Jill Gillette's part, and even just the lack of just the awareness of I guess the court or being caught in her victimhood, is that she didn't anticipate that in after she just made excuse after excuse as to why she couldn't have met that deadline. She didn't anticipate that the judge would say, well, why didn't you submit an extension? And she doesn't
And
even
did you
answer that.
notice she didn't even respond? Yeah, she didn't even respond to that.
She's moved on to the next thing, and she didn't even address that part. And it's like
Right.
it's almost like she honestly felt, as long as she said, Judge, I'm really damn busy. I got a lot going on, that he'd be like, oh, you know what? That's
Yeah.
a great argument, Jill. That you're good. But no, anybody would catch her in that shit and be like, what the fuck are you talking about? You're a county
Well,
prosecutor. Act fucking professional. Get on these
and
fucking deadlines.
like we said earlier, I think we both agree that she probably would have been better off hiring a legal assistant than she was a security person. So
Yeah, really. Yeah, no shit. Yeah.
But here, we'll go ahead and start this up again. I'm enjoying this, man. This court hearing was one of the. I just enjoyed watching this judge take control of this hearing. And
I did too, man. I did too. It was awesome.
Yeah, we shouldn't be hold up too much. If we stop this very much, it's going to slow us down.
Your busy calendar and considerable workload that you have, but the court's inclined to enforce its deadlines. The court, in this case, allowed 7 days, and even again construed liberally to be 7 business days. You're out of time, and the court, this close to trial, is not inclined to grant the state an unrequested extension. And so the court will enforce its earlier deadline order in the case and will dismiss count 1 of the information, which is, I think, even under the most recently filed one. Yes, is count 1, disorderly conduct, the Class C person misdemeanor charged in that particular count.
That's huge.
Furthermore, especially in
now it is huge, but it also begs a big question, because they do continue on with the other charges. But Justin, the fact that this one is gone, I mean, we've kind of talked about this, and we really don't have an answer to give people as far as why this would continue now that the original charge that brought the officers to the scene.
Yeah.
I mean,
well, and we won't know about that. But what's so huge to me about it is that it's such a huge part of it, and it was entirely avoidable. It was only because Jill Gillette didn't meet that deadline that charge is dismissed. Had she met the deadline, that charge is still there, and they're going forward with it. And I think everything looks differently, regardless. What you were just talking about there. However that plays out.
Yeah.
This is huge, and it's huge because it was so avoidable.
It's an unforced error.
It was entirely up to Jill Gillette, and it was in her power if that charge going forward or not. And she dropped the ball in just a huge way, man. I mean, it's almost head scratching that wouldn't be a priority, no matter whatever else she had going on. That wouldn't be a priority on her to-do list to make sure that she met that 7-day deadline so that charge goes forward. It's entirely on her.
Yep.
And it's just a reflection of just how piss poor of an attorney she is, and how I think lazy, man. I just think she's fucking lazy. I mean, and you can tell in the way she looks and just all that she's just lazy.
Well, there's an arrogance level there that thinks that, I mean, when she comes in and tries to explain this stuff away with, oh, Judge, I was busy. I think she thought that kind of stuff was going to be okay and was going to allow her to slide through. She may get away with that stuff in Webster's court. I've watched in there with Jill that gets away with quite a bit of stuff in Webster's court, but I don't see Judge Ricky going for it. I watch Webster's court quite a bit, and she does whine in there. And some of the other people might comment about seeing her in that courtroom. And when she does a little whine, and Judge Webster has a little sympathy on her from time to time, but I don't think Judge Ricky's buying any of it.
Well, that's the other thing. It's like good. It's good that it's just a piss poor reflection on her and her office, and frankly how serious she's taking this. I mean, again, that should have been a top priority because it's such a big part of of the entire case, that disorderly conduct charge. And all she had to do is submit the deadline, and she couldn't even do that. It's fucking,
Right.
it's a head scratcher, man.
Well, here we go. She'll get it figured out by the end of the week, or she'll have a tough time in trial next week. That's for sure.
Well, the thing about it is when you're incompetent, you're incompetent, man. I mean, she ain't gonna, she's had her whole life to get it together.
Well, and you got to hand it to this new attorney of Roberts. I mean, Chris Pate is his name. I mean, he's doing a good job of bringing out the problems in the case. That was the main reason that I wanted to go down there and get involved, is because the attorney that he had before wasn't really getting her done.
Oh, he was terrible. He was terrible.
Let's see if I can get this to, well, I hope we don't have this kind of issue. Would this be our one technical glitch for the evening?
Well, we got a whole bunch of thunderstorms rolling through right now, so it's out of our control.
Yeah, we've had quite a bit of storms coming through. You guys, I think it made national news. I saw in my my feed earlier, they had a big swatch of the Midwest getting the worst storms we've had in months.
Yeah, so while this is still buffering here, trying to come through, so that disorderly conduct charge has been dropped, dismissed, and then also the battery on law enforcement was reduced to just misdemeanor, just battery. So that's what's happened already in this hearing so far, and both of those are the direct result of Jill Gillett. And
there's a whole ton of guessing we can't even charge, and I've had lots of arguments with OJ, and so have all the other prosecutors, that we can't file specific statutes because they're not in the system. You just have to find what's best or closest, and they don't have a miscellaneous to let us fill in what one is.
All right. Mr. Pate, do you dispute that that's how the system works?
I'd probably have to ask my legal assistant, Your Honor, but I don't have any reason to doubt that.
Nor do I. So do what you need to do, Ms. Gillett. We'll deal with it when it comes up. But with that said, the court's going to direct that the state's witnesses may refer, if necessary, to the fact that Mr. Walker's original arrest may have been based. He was arrested for disorderly conduct, though, again, it's not going to reflect that he was charged. But neither party is to refer to the reasons for the dismissal or that the disorderly conduct charge was ever dismissed. Perhaps because we're going to be dealing with counts 2, 3, and 4, maybe the jury will naturally infer that count 1 was a disorderly conduct charge that was dismissed. I see no useful purpose to either side getting into or arguing regarding the disorderly conduct count. But I hope it's clear that there probably needs to be some explanation to the jury as to why there was an arrest in the first place, which I think led to everything that followed. And obviously, since that arrest apparently was based on suspicion of disorderly conduct, it seems only fair that the state and the state's witnesses may refer to that. But I don't want some explanation or commentary as to the reasons for the dismissal or that even the count was dismissed. Any clarification needed about that, Mr. Pate?
Well, Your Honor, that does bring up another question that I can address by a motion in limine if necessary. Other than the fact Mr. Walker was arrested for disorderly conduct, which I think certainly is a relevant fact because we have to discuss why he was under arrest if we're going to deal with the battery and the interference charges. I think it renders his actual alleged conduct before the arrest irrelevant. And I guess what I'm saying is I don't think the state should then be allowed to go in and detail every single thing that happened before Deputy Bliss arrived, because it's simply not relevant to whether he committed an interference with law enforcement or a battery on either Deputy Bliss or Deputy Watts. It only serves to prejudice him in front of the jury.
I see your point, Mr. Pate. Your response, Ms. Gillett?
Judge, we can play because everything from the time that Deputy Bliss has contact with him on is on video. So we're basically going to play those videos. And if you don't have to bring in all the other extra witnesses, that'll make the trial much shorter.
Okay.
So.
Essentially, I think where the trial is going to pick up is what happened at the jail. Would you agree, Ms. Gillett?
He resists being handcuffed or going over to the jail beforehand as well.
Now, see, she just right there lied again, Justin, and she does this quite regularly. She misconstrues what happened. She said that he resisted being handcuffed. And maybe we should have pulled up that video, but everybody probably remembers it anyway. He when she said you're under arrest, he held out his hands and said, cuff me, or I didn't think he said cuff me, but here you go. And he did not try to resist that. He offered his hands for her to cuff. She not only refused to have him cuffed at that point in time, but then she asked him if he had a weapon. He said he had a pocket knife, and then she tells him to get his pocket knife out of his pocket. So let's really think about how dangerous she thought he was.
Yeah, and I think what happened is, when he sticks out his hands, his arms to be arrested, and she doesn't do it. And I think before she asks him about the pocket knife, to remove the pocket knife, I think she told him to turn around, put his hands behind his back, and he did that as well. And that's when she said, "You have a weapon." So he presented two opportunities for her to handcuff him, and so it's like the opposite of resisting arrest. He was like, "Fine, do it. Here, take me." And she was resisting the arrest, is what it was.
But she's going to say to the judge, she's going to say to the judge that he resisted being handcuffed. Well, he offered her two opportunities at least to handcuff her.
Yeah, and that's all. And that's not even how it should work. It shouldn't be he's offering her the opportunity. That cop needed to take fucking control of the situation, and if he was under arrest, he needed to cuff his ass.
Right.
That's the way it should have happened. It shouldn't have been pussyfooting it around. Here, you can cuff me, you can't cuff me. What's in your pocket? Take that out of your pocket. No, she needed to take command of that situation, and she didn't do that. And now they're going to say that he was resisting arrest over that? That's fucking bullshit.
I'm getting tired of hearing this prosecutor lie in court as well. It's really getting frustrating.
There's body camera from the moment Bliss arrives at the courthouse.
Yes, there is.
So
and it doesn't show him resisting arrest.
There's interaction with Bliss and him, or Mr. Pate and I can get together and look over the video and determine the exact spot where we start. And then we'll go through everything in the sheriff's office.
All right. Now, if you look at your bill of particulars in regards to count 2, interference with law enforcement, 2 of the 3.
Now I must have missed this earlier, Justin. He's referring to the bill of particulars for count 2. That's awesome. That must mean he's going to hold her to it.
Yep.
Awesome.
Clearly took place at the jail, refusing to be booked, refusing to answer booking questions. The only remaining fact would be resisted arrest by yanking away from Deputy Bliss. Where did that happen at?
Once outside the courthouse and once in the jail.
Having reviewed the video, Mr. Pate, do you agree?
I'll have to review it again. I think probably. I think I'm not agreeing he did that.
No.
But I think there might be something she could argue at that point. So I think we could probably figure that out.
All right. Well, that's where the video is going to pick up. It's going to pick up at the first allegation by the state that he somehow interfered with law enforcement, and appears to be limited to yanking away from Deputy Bliss, because even the state's own recitation of the facts seems to suggest that's what they're alleging, not any other conduct at the door. And I don't know if that happened during the transport to the jail or still at the courthouse door. I'm a little concerned exactly what yanking away means. I mean, what movement is considered actually resisting law enforcement? I suppose maybe it's obvious from the video, but I do hope counsel can resolve that issue and start the video at an appropriate juncture. Mr. Pate, I appreciate your confidence that you can do that. All right. I also am going to set a deadline regarding the filing of the amended information in this case. Again, Mr. Gillett, I know you're busy. I just need to make sure that that's on file prior to our trial date. I'm going to set a deadline for noon on November 5, which I think is the day before trial.
Anybody think she'll make the deadline?
I think Mr. Padar, already knows what's coming, but I do want to have him to have an opportunity to look over what is going to be labeled as the 4th amended complaint information, just to make sure that it's in compliance with the orders of the court made here today.
Hey, you stop for a second.
Yeah, because that's the fourth time.
It's interesting that they're going over trying to nail down the details of when this particular yanking away or the resisting of the arrest happened, when that the disorderly conduct charge has been dismissed and there shouldn't have been arrested in the first place. They're kind of trying to square, get over these little details about when the resisting arrest happened, instead of being like, well, he shouldn't even have been in handcuffs at this point because the fucking charge has been dismissed. There's nothing there.
And that's the question we've asked all day, and I've asked a number of different people, and I know you have as well. We haven't got a good answer for how that proceeds, but the rest of the case is proceeding without that underlying first offense that brought the law enforcement there. We're going to have to work to understand that a little better before we get to trial next week, because I definitely want to understand how that operates a little better. My understanding was this would be more of a fruit of the poisonous tree kind of thing, where if you lose that first charge, pretty much anything after it would drop off as well. But obviously my thinking on that was wrong.
Yeah, well, and it's going to be interesting as well, because there is a civil case that's filed on this as well, and it stems from the unlawful arrest aspect of it, of being arrested while exercising his First Amendment right. Well, that reason has just been dismissed. There's no charge there anymore. So that's going to be interesting on the civil side how that plays out, because there's no charge there now.
And there's no way that she's going to get a conviction on it. So that, right now that charge no longer exists. So
Yep.
Right. So we're buffering a little bit. Oh yeah, the fake back injury. If
you can do it sooner, if your office can get that done sooner, Mr. Gillett, greatly appreciated. But the deadline's noon on November 5.
She's sad.
Yeah.
All right. I think that given the severity level 4,
she's been slapped around so much.
8 peremptory challenges apiece, counsel.
And it's not over.
Nope.
I don't mind if there's 8 or there's 6. We've done it both ways.
Well, based on severity level of the most serious offense charge, that will determine the number of peremptory challenges for each side.
D, I saw your question there. Yes, Walker already has an attorney on the civil side, and the 1983 suit has already been filed. If I'll get a reference for that, if you guys want to pull the case, you can. It's on Pacer, but I'll get a reference up for that.
His civil attorney is the same civil attorney I'm using, Linus Baker.
Right. Yep.
And that's one of the things I like about us getting involved there, is that we're able to connect him with a good civil attorney as well.
Right.
Check that. Let's get that issue resolved now.
Well, and I think we have potentially another issue, Your Honor,
well, let's resolve this one first.
Well, I think this issue I'm about to raise may impact the other issue. In the second amended complaint, which was filed immediately after the preliminary hearing on November 13th, Mr. Walker was charged with aggravated battery on law enforcement level 5 person felony, which is what I believe Judge Lee bound him over on. The bill of particulars, which was filed this morning, now has that count as a severity level 4. And I just now caught that.
Is that consistent with the most recently filed charging document, which again was just filed this morning?
In the one filed this morning, it's a level 4. In the one we've been operating under from the conclusion of the preliminary hearing on, it was a level 5. And as I look at that closer, it has the same issue as count 3 does. There's no allegation in the body of the text of Deputy Watts being a properly uniformed or identified law enforcement officer.
And see, here it goes again. She has sloppily put, and you're going to hear the judge refer to her paperwork as sloppy. She has done a sloppy job and turned this in past deadlines and everything, and she hasn't laid out the complaint properly to show in the complaint that this is a law enforcement officer. And I love the fact that the judge references that anybody can be named anything. You know, I mean, you might have a kid pop out of the womb being named Deputy Jones.
Yep.
You know,
Yep.
Who knows
Yep.
these days.
Exactly. And she's such an embarrassment to herself, obviously, and she's an embarrassment to the county prosecutor office, and she's an embarrassment to just attorneys. This stuff here is just like you would and it wouldn't expect a law student to drop the ball on. She needed to do a much better job of lawyering and writing up the details and the charges for this. Otherwise, what's the point of her being in there? I mean, anybody could just write Deputy Bliss. We needed to have some sort of legal analysis there, Jill, some sort of application of the law, and then writing it out in a professional, lawyerly manner, and then presenting that to the court. Instead, she's like, it looked like probably last minute, ego driven. She thinks it's going to get through no matter what. And I don't know if she's just never been held accountable before, but she's being held accountable right here.
That's exactly what it is. And I'll just go ahead and say right now, you know, I had put in an ODA complaint on her for the lies that she told about Justin and I. And that complaint basically got denied by the office of the disciplinary administrator because this is an active case.
Right.
Now, they didn't deny the allegations. They didn't dismiss the charges that were levied there, but they basically put this aside. And they even suggested you can try to refile this after this case is over. Well, I'm serious. Jill just keeps adding to that complaint with every hearing that I watched. There's more to add to that complaint. So she would have been better off with the ODA would have picked this up a month ago rather than what's going to happen when this case is over.
Right. Yep. No accountability whatsoever. Yep.
Well, she's not used to being held accountable, but I'm not letting this go. She told some lies about us. She tried to hem us up on charges down there. She tried to intimidate us. No, I'm not letting that go. And that ODA complaint will be refiled, Jill, just to let you know.
And it was all so unnecessary. She didn't have to do any of that stuff to us. She didn't have to make up any of that stuff. She didn't have to try and pursue these kind of charges to scare us away.
Exactly.
It was all unnecessary. She brought it all on herself.
Exactly. John asks, are you talking about a bar complaint? No, John, this is a Kansas Office of the Disciplinary Administrator. You can Google that. And what it is it's a team of lawyers who examine the conduct and the filings of other attorneys if there's complaints made. Now, Doc and I haven't had much luck with getting any kind of justice through that committee. I've done a couple of them. One of them was on a prosecutor that withheld evidence and then refiled charges. But this is a state level agency that can actually discipline the attorneys. They can't actually take away their bar license, but they can suspend their ability to operate in the state of Kansas. That's the most that they can do to them, from my understanding. I think you do have to go to the bar to get their license revoked. Is that right, Justin?
So I think that they actually can get their license stripped through this. I believe they can.
Is it their full license or just in Kansas?
Oh shoot, that's a good distinction. I'm not sure.
Gotcha.
I think Kansas for sure.
Okay.
But also just want to also just point out there that it is a government agency. The ODA is a government agency, and if you go to that website, all of the different rules there from the Kansas Supreme Court are laid out there. So if you wanted to file an ODA complaint, you can sift through all the different rules to see what applies there. And Michael was talking in particular here with Gillett about her being unethical, about her lying, and the whatnot. And you mentioned not having luck, but with these ODA complaints. But back over the summer, Josh Seiden, the deputy district attorney there in Douglas County, dressed up as me, and his boss, the district attorney Suzanne Valdez, both she was laughing at him. It was all caught on security camera. She was laughing and joking around with it, along with the Douglas County Sheriff's deputies there. And I filed ODA complaints on them, and those are being investigated. Those did move on to the next level. So
And there's
So
a
hope
couple
there.
others involving Josh and Valdez that are moving forward, from what I understand as well. Well, shaky hands, Josh. That's right.
Yep, that's him. That's what we all know him as now. So yep, that's him.
We'll let this keep going here.
Well, you make an interesting point here, Mr. Pate. I'm looking at the most recently filed charging document in count 4. While charged as a level 4 person felony, again, there's no reference in the text that this was a battery against or an aggravated battery against a law enforcement officer.
Oops.
Ms. Gillett, I think he's right.
And her lame ass excuse here. A deputy's a deputy.
Both of them as deputies.
A corrections
Just
officer is a
listen.
corrections officer.
This is great.
A game warden's a game warden.
Mr. Gillett, it's an essential element of the offense. We're just supposed to glean by the word deputy that's not part of their name. I mean, who knows? In today's world, people name their children anything. You just list that individual as Deputy Eric Watts. Are you saying that in and of itself constitutes a declaration that this was a law enforcement officer?
It does when it's described as aggravated battery on a law enforcement officer. If it was a KHP officer, it would say trooper. If it was a game warden for the Kansas Department of Parks and Wildlife, it would say game warden. If it's a correctional officer, it would say corrections officer.
That's so lame, man. That's her best argument right there.
Right. It would say all that, but then it would also say a certified law enforcement officer of such and such department or county. That's normally how these things say. Exactly.
Yeah.
But she's too lazy to add those extra words that that are right now catching up to her.
But just think about it. You talk about answered prayers over there. Robert Walker sitting there got to be in. Oh man, this is great. She just totally is dropping the ball. All she had to do is just type in just a few more words to make it clear that this is a law enforcement officer, and she couldn't even do that. Oh man,
and
awesome.
Robert's attorney's got a hell of a poker face, man, because he's not even getting impacted by this at all. He's just sitting there letting her case fall apart and taking it and not even having a response.
Once it's collapsing, just stay out of the way, let it go down. Yeah.
Exactly.
I think that the law specifically says, and I want this on the record for appeal, that the complaint should be liberally construed to allow grammatical errors or intent.
Well, I'm sorry. I'm going to have to stop it right there for a second because, Jill, the Cora law says this law shall be liberally construed to say that records are open unless you have an arguable reason to close records, not just citing a statute and saying you can't have this. So there's your... Yeah, Sheetable blows my mind, and this is how it blows one way, but not the other.
It's kind of like when she tried to say that it was narrowly tailored to restrict me and you, and that's not what narrowly tailored means, Jill. It doesn't mean you got to just apply it to two people.
Right. Exactly. Exactly. Woman is nuts.
How many attempts should your office be allowed to get this right, Mr.
I love this.
Should this court reward sloppy work?
Oh,
in the prosecutor's
sloppy.
office?
What's your answer, Jill?
He said sloppy.
I mean, you filed multiple amended informations here.
Multiple.
Scrutiny of a charge should be made by the prosecuting officer in this case and their staff to make sure that the charge reflects the severity level of the crime that you're attending to charge, with sufficient recitation of facts within the complaint to make it clear exactly what conduct that you're charging.
Pate's over there covering his mouth. I think he's
it's
smiling
clear
there.
that they're law enforcement officers, and this is being charged as battery on a law enforcement officer.
That's her argument. I think it's clear that that's what it is. Like the judge is like, I don't think so. I don't think so.
I like
Jill.
this. I didn't catch this earlier, Dick. I love that. He does look frustrated and puzzled on this because she's not making a very good argument.
She's not. It's like her approach is, because I'm saying it's the way it is, that's the way it is. Like, no, Jill, you actually have to put forth a little bit of effort there.
Good video, Dick. I love it. That's Dick over at Kansas Freedom News. Somebody pin him in your descriptions. Kansas Freedom News. You got to go over there and subscribe. He's the reason we're on this case in the first place. I think we're at that point where the judge is going to have to take a break here.
Yep, he does.
The good thing is you guys aren't going to have to wait through that whole time like we did. We're going to skip right over his break time.
All right, counsel, I'm going to take a brief recess.
Yeah.
For ruling on this matter. Stay with the meeting, counsel.
Yeah, so he takes.
May I step away just very briefly?
You may. This will be a 5 to 10 minute recess.
Okay, thank you.
We'll reconvene.
Jill's like out of there. She's turning her camera
We're in
off.
recess at this time.
She's so fucking embarrassed. If she has a shred of self-awareness, she should be so fucking embarrassed and questioning why she even became a lawyer.
And that's the thing. I'm going to get this thing queued up to where we're past the break. But that's the thing when when the judge has to take a break to consider the arguments. I mean, and it's just as simple as you didn't file the proper paperwork. You didn't file it reading the right thing. I mean, come on, girl. You can do better than this if you're going to be a county attorney. I got to tell you, Elk County citizens, when you go vote next week, you might want to consider this. I know you don't have another attorney on there, but not necessarily. Just don't vote for her because it's going to reflect in the numbers.
She's up for re-election.
I don't know if she is or not. Somebody put in the chat. Does anybody down there know if she's up for re-election? And if she is, I just suggest don't vote for her. Don't let her have those numbers.
Yeah, I don't know why anybody would vote for her.
Exactly. So we'll go ahead and continue. He's come back from the break.
The pattern instruction setting forth the elements of an offense of aggravated battery against a law enforcement officer or court official. I will state, and I think in support of the court's continuing position, that number 2 requires that the state prove, and therefore, in the view of the court, originally charge, that an individual was a uniformed or properly identified county law enforcement officer. The charging document does not set forth that language. And that it's not just some reasonable inference that could be drawn by use of the term deputy. I think that the state has to actually charge that this was a uniformed county officer or whatever department the person was with.
D. Smith, I 100% agree with what you say there. If she had an ounce of integrity, she would just let this case go. But I got a feeling she's dug in her heels and she's going to stick with it all the way through the ride.
Yep, no matter how bad she looks in the process.
Yep, and it's only going to cost her more, but she can't see that.
And in this case, therefore, Mr. Pate's oral motion for essentially amendment and or dismissal of count 4 will be granted by this court, because again, the state has had multiple opportunities to clarify this point and bring that charge within the proper confines of the statute in this case. And the court will grant the motion and show that count 4 is to be amended simply to a count of aggravated battery, which begs the question, how will that affect severity level given the current language of the charge that Eric Watts essentially was subjected to an aggravated battery, but not as a law enforcement officer, but merely as an individual, given the language of the charge, which was physical contact when done in a rude, insulting, or angry manner, causing great bodily harm or disfigurement. Ms. Gillett, you've handled a number of these cases. Do you know right offhand how that would affect severity level?
And Your Honor, I don't want to muddy the waters anymore, but I'm afraid I'm going to.
See, this, I love his attorney, man. He is speaking in, he's making arguments. I mean, guys, if you watch the first hearings that are out on Old Squishy's channel and at Meg's Crime Watch, I think this is where one of the other ones is. But if you go watch those, his previous attorney was a guy named Gary House. I'm sure Gary House was a great attorney when he was about 30 years younger, but the guy is old, needs to retire, didn't watch the videos, admitted in court he didn't understand social media and anything when Jill was making a bunch of bullshit arguments about all the social media stuff that was affecting her. And then he pretty much wasn't making any kind of real argument to try to help Robert. And that's the biggest change here is Chris Pate. I mean, he's in here, he's fighting these different things, and he's willing to muddy the waters.
And beyond that, Gary House wasn't asserting himself whatsoever, and your attorney is a reflection of you, so he wasn't asserting any of Robert's case. And so here with Pate here, he's asserting himself, and you know that's not a big. That should just be like a basic lawyer trait. I mean, we're not asking a lot here from that, but it's good to see that he's doing that.
Exactly, and he knows the case well enough to be able to do it right.
Continue to muddy, Mr. Pate.
During the recess, I went and pulled the battery statute and also the preliminary hearing transcript that the court allowed me to have when I was appointed. Judge Lee bound Mr. Walker over on KSA 215413, B like boy, 2, B like boy, and then classified that as a severity level 5 person felony. I then went and pulled the battery statute 215413 B2B. Appears to me to be recklessly causing bodily harm to another person with a deadly weapon or in any manner whereby great bodily harm, disfigurement, or death can be inflicted. And then I went to the penalty section for that, which is in H1 or H2, I'm sorry, H2D like David says that subsection B2B is a severity level 8 person felony. So it appears that the subsection Judge Lee bound Mr. Walker over on does not comport with the severity level that Judge Lee stated on the record. They're two different things. But on the record, he bound him over under B2B, which is recklessly causing bodily harm in a manner where great bodily harm could be inflicted.
Could be inflicted rather than actually caused.
Yes, it's either the alternative means are recklessly causing any type of bodily harm with a deadly weapon or causing bodily harm in any manner where great bodily harm could be inflicted.
Now, let's all remember where this aggravation comes from. If y'all are familiar with the videos and how all this turned out, this is Eric Watts, who at the beginning of this and in the hearings, we can hear him talk about this. He admits that he didn't go see the doctor when this happened. He waited so long that he was denied his work comp claim through the city and through his employer. And so she amended this later on because he claimed all these back injuries and all these injuries to his back and stuff, and they've had a hard time getting the medical records. I'm assuming that since Chris Pate didn't bring it up in this hearing, that they must have finally got those. So I'm assuming he's going to have enough of the evidence from this guy's previous injuries in California, Nevada, and these other places where he'd seen neurosurgeons and all this other stuff. And he's trying to blame those aggravating factors on Robert. But if you go back and you watch the arrest video, the reality is Robert didn't attack anybody. Robert didn't really do anything aggressive toward those deputies. This guy literally attacked Robert, lifted this man off the ground, threw him into a corner, and started choking him.
And Robert was handcuffed the entire time. He was handcuffed. I was thinking, Robert's got to be sitting there thinking, this motherfucker attacked me while I was handcuffed, and he hurt himself?
Right.
How the fuck did he hurt himself? I was a defenseless person with my hands cuffed behind my back the whole entire time. And
exactly.
I caused injury to him? You gotta
but
be
that's how
me.
The justice system works, man. The justice system works like that every day, and that's what they're trying to do here, man. It's bull.
It is, man. It's
page of the transcript that you're referring to?
47.
Thank you, Mr. Pate.
Starting at line
Exactly.
6, I believe.
I do find that there are sufficient evidence for probable cause to bind him over for arraignment on that subsection.
Yep, you're right, John. Thanks, Brandon, for putting that up there. You guys all go over and subscribe.
I don't
to
think
Dick's
he
channel.
got into the detail that you did. I think you're just interpreting the language of the statute here, Mr. Pate. He did say recklessly caused great bodily harm.
Because B2B for a normal person is different than B2B for a law enforcement officer, and a law enforcement officer is a level 5.
Happens all the time, Juggalo.
Well, right now, I'm not dealing with the law enforcement officer question, but rather what type of aggravated battery did he bind over on? If you look at the language on page 46, Mr. Pate, there's probable cause that he recklessly caused great bodily harm. That is consistent with the language that Ms. Gillett has used in her most recent charge in count 4.
Thank you, Firm.
In other words, she's alleging that it was actually caused here, not just done in a manner where it could be caused. I think her position is it was actually caused. Am I correct?
Yeah, I agree with that.
All right.
Sure, he does. He agrees that she actually saying that he actually caused it, because why would he? Why would he argue with that? Because now she's pinned herself down into that again. That he's referencing back into that bill of particulars. She has pinned herself into that argument, and she needs to make her case. Now, the one thing that we talked about earlier, when she wrote that bill of particulars, Doc, she had that disorderly conduct supporting everything.
Yeah.
And now she has to move forward with the bill of particulars that was predicated on that disorderly conduct, but detailed these other charges as a result. And she doesn't get to go back and change that now.
And again, she only has herself to blame for that as well. That disorderly
Exactly.
conduct charge would, in theory, would still be there had she not dropped the fucking ball. Jill has to be thinking this is the worst day of her life, and that she's waking up from a dream. I mean, it's just one hit after the next throughout this whole thing. Like, she didn't win a single fucking thing.
Well, and the worst day of her life is the fact that she's doing this with the spotlight on her over the way that she's been doing this for the last year. This happened, this original situation happened in June. I think it was June 26th of 23. So here we are a year and 3-4 months later, and we're going to finally get to an outcome in November of 24. I mean, that's a long time for Robert to live under these charges and to have to deal with the threat of going to jail just because he spit on the sidewalk wrong and somebody decided to yank his bond or something like that. And that's not a way to live.
Nope.
And that's what she's done here.
He was facing serious time in prison. Years.
Exactly.
Years.
Exactly.
Wasn't it initially like 11 years?
Something like that. Well, he had the 2 felonies. Yep. Because they had at one point she had escalated it to 2 felonies. From what I understand, if I remember right, it started with a disorderly, an interference, and a battery LEO, and then she raised them. She raised it to felony, in my opinion, to try to intimidate some people, and got to playing with their different charge sheets. And that's the other thing. She seems like she's ran out of times to amend her charges, playing games with people instead of just doing her job.
Yeah, I mean, yeah, it's a cycle. It's like a psychological game that she's playing with Robert from top to bottom. I mean, just imagine, like you were saying, they're living with that over your head this entire time, while knowing that you were the one that was attacked and didn't do anything wrong. And also, just think of the psychological game they're playing. Like when you're handcuffed and you're in the sheriff's. You're in the jail by yourself and your captors are attacking you like that. They had a fucking dog in there. The lady deputy pulled her fucking taser. There's nobody in the world there that's gonna fucking do a thing for you, and you can't even protect yourself because your hands are behind your back. as you're being attacked by your captives. You can't get out of there. You can't go anywhere. You have to fucking deal with it. So top to fucking bottom, Robert was put through the fucking ringer psychologically, obviously physically. He got fucking choke slammed down there, but just psychologically, it's like fucking torture. They like tortured the guy.
100%.
Now
Now they're continuing to do it.
Yeah,
they're
he's sitting in
continuing to do it.
court. Yep, he's sitting in court and he still could go to fucking jail for it. It's complete fucking bullshit, man.
But guys, here's the thing. You know, the only way you get to a situation like this where you have a prosecutor having the worst day of her life is if you stand the fuck up and fight back.
Precisely.
Don't let them do it to you, and don't let them do it to your neighbors. Somebody's got to stop this shit at some point, seriously.
And that's why, you know, it's important to read everything. So it's important to read everything.
I don't think he said.
All these things that are being caught are just minor details that Jill overlooked, that if you're not paying attention to yourself, they'll slip through, they'll pass through.
Dude,
and whatnot.
these are the things.
but
these are the things that they use to dismiss civil cases as well. When your civil attorney makes a mistake, boom, your case is gone with prejudice. You know, and it's over. This is the same situation.
Says capital B. I think he said B2. I think he had B2A down as actually causing the bodily harm, and that is a 4. B5 is a 5, but he found it was a 5.
But for a non-law enforcement officer, it's an 8, correct, Mr. Pate? Looking at the penalty section?
If the great bodily harm does not actually occur, yes, Judge.
Okay, and if it did actually occur as alleged by the state?
I think that's a 5 if it actually occurred.
It's a 5.
That was consistent with the probable cause finding made by Judge Lee, and it's also consistent with the charging document, which has been filed by the state, that there was an actual recklessly causing of great bodily harm. So you're conceding, Mr. Pate, that would be a level 5?
With the actual great bodily harm, yes, I would agree that would be a level 5. So I think Judge Lee found that probable cause for that factual basis, but the wrong part of the statute may have been cited into the record.
All right. Well, again, the court's going to make its rulings based on the actual factual findings rather than the legal interpretation of those findings made by the magistrate court. And
the court also found that Deputy Bliss's was a Class A law enforcement misdemeanor. Well, I don't think
he need not make any findings regarding misdemeanors.
Yeah,
that's right.
The preliminary hearing is to determine probable cause for felonies, not misdemeanors.
And there's only one felony here, Your Honor.
All right. Well, what is now count 4 essentially is going to be treated by this court as a severity level 5 person felony charge involving recklessly causing physical contact with another person when done in a rude, insulting, or angry manner, causing great bodily harm or disfigurement. I don't know if there's really a disfigurement claim here, but.
All right, so I'm going to touch on this real quick. Bliss wasn't touched. Her claim of the battery is when she's manhandling Robert going in the room, she scrapes her knuckles or something on the wall. Is that right, Doc? Isn't that what I remember?
I'm not sure about that.
Yeah, but her injury was not directly caused by Robert doing something to her.
No,
it was as a result of.
If it was her knuckles on the wall, I don't remember.
Yeah, she had hit her arm or something like that on the wall as she was trying to move him into. No, that was Watts. AB says maybe AB put it in the chat.
Bodily harm to
what
Eric
Bliss's
Watts.
was.
Quite frankly, given the court's ruling.
I thought she said she hit the door or
in
something.
The 4th amended complaint information, that's how it should read.
Her spirit is chin steeped
Proper
in
citations to the appropriate part of the aggravated battery statute and the penalty section as a severity level 5 person felony. So your attempt to muddy the waters, Mr. Pate, I think essentially results in lowering severity level from 4 to 5.
Oh hell.
So there's another L that Jill took and another W. Even though that charge is still there, it dropped in severity. So one dismissed, one completely lowered from a felony to a misdemeanor, and then this one has now been lowered from a 4 to a 5.
Right. And I don't think we're done here yet. There's still enough fun left here.
The hits keep on coming. Yeah.
Right.
Yeah, the court's findings that count 4 would be charged as a level 5.
All right. Furthermore, Mr. Lett, you may want to talk to the clerk of the district court just to make sure that you can't renumber a complaint. I know that the Odyssey program has its limitations, but if there's a way it can be done properly, this court would greatly prefer that there be a 3-count Fourth Amendment complaint information without necessarily a reference in that particular document to the dismissal of count 1. If it can't be done, it can't be done. But if anybody knows a way around it, it'd be Aaron, our clerk of the district court, and you may want to check with her to see if the system might recognize that amended charging document with essentially renumbering or retooling the charges of the complaint. I don't think that changes the number of peremptory challenges, Mr. Pate, despite your muddy waters attempt. I think we're still at 8 peremptory challenges for each side. It would be the intention of the court to seat 1 alternate. Further, I want to reiterate at this pretrial conference that it's still the intention of the court to limit during voir dire the jury questioning portion to only courtroom participants will be allowed in the courtroom physically. There will be no exceptions. If you're not a specifically authorized court official, you will not be in there unless you're a prospective juror, prospective jurors only. To the extent to accommodate the public, I think there'll be a YouTube broadcast that will be accommodated locally. It's the intention of court staff to set up a room or a facility either at or very near the courthouse to allow the public to view those proceedings. There will not be any spectators during jury.
There was one point where it looked like she just like impulsively just like checked her phone, like she wasn't like she didn't like get on it to do anything. She like picked it up, checked it, and set it down, as if like people have that compulsion to do that stuff with their phone. That's what it looked like she was doing.
Well, let's not forget the hearing last year when, it was earlier this year when Robert was shaking his head and stuff, and the judge called him out and threatened him with contempt and jail and shit if he didn't stop acting out in court. Well, what's considered? This is another one of those times. What is actually considered a disruption for the court?
Right. And at a minimum, it's very unprofessional, because even if she is doing some kind of lawyer work on her phone, it still looks like she's maybe like checking like her Facebook or texting with someone about picking up the kids after school or something like that. It just looks bad, but whatever, Joe, keep doing it, I guess.
Big question. And once a jury is selected and paneled and sworn, then at that point, the court will allow it to just be an open courtroom. As long as there's no disruption by any member of the public, they'll be allowed to fully watch and participate. And Mr. Walker, yes, my prohibition does apply to even your immediate family members, but they can come to the courthouse and they can watch it on YouTube.
A judge requests that there is no recording, live stream, or anything of the jury proceedings. We have had lots of issues with live streaming, everything they can possibly live stream.
We're live streaming right now, Jill.
I don't know what she's talking about.
I have not been notified of any applications for anyone to be able to record the proceedings other than the courts and the official court record.
Well, what you're essentially requesting is a closed circuit broadcast to this other room for the public, correct? Rather than a general YouTube broadcast, correct?
Correct.
I'll talk to my staff about it. I
They're
see your
talking
point,
about just
and it's a
during
valid
jury
one,
selection, guys.
and I will address that with the court administration.
The actual will will be in open court.
All right.
This is just jury selection.
Mr. Pate, I am sure that there may be other pretrial issues that we need to discuss. Do you have any?
Just a moment, please, Your Honor.
Sure.
This is another thing I like.
Okay, we'll address that in a moment.
Pate consults with his client. That's another thing I like about him. You know, before he answers,
I don't think I have anything at the moment, Your Honor.
All right. I think Ms. Gillett identified that she may have an additional issue. Ms. Gillett?
Judge, I'll have personal security.
Here we
with
go.
me. It's a deputy from a neighboring county. From the moment that I step on courthouse grounds to the moment that I leave.
Now, Clinton, I'm glad you're still here. Yep. Now pay attention, Clinton, because you have been hired for some new job, apparently, that you didn't know about.
To the death threats against me due to this case. And I asked permission for that person to be with me in the courthouse. Even when I'm in the courtroom, I can't do my job and watch my back. Same as you can't do your job and watch your back. And it's just one extra person. They've been sworn in as a special investigator for quite a while, working on a different matter for me, because we hired them to do a bunch of technical media work on a case that we needed someone with that capability for. So I'm asking for permission to have the extra security that my office is having to pay for me.
Is this person currently associated with a law enforcement agency?
Yes, it's a Greenwood County deputy that lives in Elk County. It's Deputy Clinton Hanson, who used to be on the force here.
Clinton
He will
Hanson.
be allowed.
Clinton, you're going to be allowed in court as her own personal security guard. Just wanted to make sure you knew that. I just think it's great that we got a Clinton Hanson.
I'm not going to put any
that's
particular
not the same
limitation
guy.
on.
Yeah, what are the odds? You know, what are the odds?
And you know, AB
Presuming that
makes
they
a
have
good
some
point.
sort of law enforcement related
Let's
function that they're attempting to
produce these
exercise.
death threats.
That's exactly right. That's what I was going to say.
The only thing I'm aware of one, and I don't mind calling him out. His name's Robert Desmond, is what he goes by on YouTube, and he left a comment on my channel, basically admitting to what he said. He's the one that called down there and said something to Jill, or said something to their office about he was going to come down there and drag her out by her hair and string her up in a tree or something like that. And that's nothing that any of us have endorsed or asked for. So any jackass that wants to do that's on his own. But his name was Robert Desmond. And, you know, when she talked there just a few minutes ago about having that technical case that she's working on, the technical media investigation, I'm wondering if that's not her either trying to drum up something on you and I still, or whether she's actually investigating those threats and trying to find out who Robert Desmond really is.
Why? What did she say about the what makes you think?
It was just a couple minutes ago when she talked about having to hire the security. Here, let's
You don't
go
have
back.
you don't have to go
allowed.
back. But I was just saying, like, what makes you think that? What makes you think that?
Well, let's listen to what she says here. I took it back just maybe a minute or so here.
I'm not going to put any particular limitation on the presence of law enforcement officers.
Oh,
presuming that they have some sort of law enforcement related function that they're.
Sorry, guys. I think this is important to hear, though. She's talking about
for quite a while, working on a different matter for me, because we hired them to do a bunch of technical media work on a case that we needed someone with that capability for.
technical media work.
So I'm asking for permission to.
And that's what I'm talking about. She's talking about hiring somebody specifically for technical media work. And so I guess I'm wondering, technical media work. I mean, it's obvious she doesn't understand what we're doing. So she hired somebody to investigate us, or maybe she's hired somebody to investigate the threats that she keeps alleging. I don't know. Either way, I mean, if she's coming after either one of us, she's going to have a tall hill to climb. I hope she gets to the bottom of the threats, because neither of us endorse that. And if somebody threatened to come kill her, then that's a problem. But that's not something that either of us have been a part of.
No, and I wonder what the tech is called, technical media something or other. I wonder what she's even talking about there.
Yep, technical media. Yeah, and she made. You guys with the comments are great.
Well,
Hired someone.
she had made reference to
Have
there
the
had
extra
been
security.
already been so many issues with the live streaming,
Right.
and so first of all, I don't know what. I mean, there might be things I don't know what she's talking about. I haven't
Well,
seen these things live streamed out there in terms of things that shouldn't be live streamed. So I don't know.
well, and we can look back to the thing that she filed, the motion that she filed in Robert's hearing back a couple months ago, when she claimed that these media personalities and all this other stuff, and had doctor in quotes for you, when she named people in that complaint. Clinton's one of them. She named Todd over at Generally Specific. She named Andrew out there questioning their something. I can't remember it now, but she named different people in here trying to allege that we were a part of something. And the only thing that I've ever found any evidence of anything that happened, like she talked about, was that one Robert Desmond guy. And again, he came onto my channel. I started asking him, what the hell, dude? And he basically admitted to it.
But even what I was saying, what I was saying though is that she was saying that there was, just a little before that, she had said that we'd already dealt with a lot of issues with the live streaming, and so she vaguely just throws that out there, and I'm wondering if she's implying something about. Actually, I have no idea what she's implying in terms of is there an issue? Is she trying to say there's some kind of live streaming of these court cases? I have no idea what she's talking about, but she's seeming to try and imply that there's some sort of issue that these media people are doing that they shouldn't be doing, that's causing extra work for her. And I don't know what the fuck she's even talking about.
Exactly.
I'd like her to be more specific about it, but whatever.
Get her to give us a bill of particulars on that.
Yeah.
Oh, let me get some volume back up here.
Presuming that they have some sort of law enforcement related function that they're attempting to exercise.
Yeah.
With their presence. Yeah, so that's a valid request, and the court grants it, Ms. Gillett.
Thank you, Your Honor.
And I trust that you're asking this individual even to be seated with you or be present in the courtroom at all times that you are?
I was going to ask for him to be either right behind me in the gallery where he can view the entire courtroom, or because there will be a deputy near the front door, and this deputy will follow me basically to and from my office, to and from the courthouse, anywhere I'm at, just because there's been so many death threats received by my office.
So many.
Well, and not only to not allow a public court hearing, what she had also filed in her motion was to restrict the media that could access the court as well, in particular me and Michael.
Well, yeah, she narrowly construed it to exclude you and I.
And that was her argument. She's like, "Oh no, you can as long as you are have narrowly tailored the rule to restrict the First Amendment, it's fine." And in this case, we've restricted it as much as and narrowly as we can down to 2 people. Is basically what her argument was. But in essence, yeah, she is trying to keep the public out from that aspect, because if she's not allowing certain journalists in there to present it in any way, then it is in essence keeping the public out of it from that perspective. But on top of that, yeah, there was a concern that she was saying it was such a security concern there that we need to restrict access to the courtroom for everybody, really.
Right. Yep. She's not done crying.
I think I've clarified the court's position in that regard. Anything else, Ms. Gillett?
Nothing further.
All right. Again, I'll reiterate the deadline for filing of the amended, which will be, I think, the 4th amendment complaint information.
4 times.
By noon on Tuesday, November the 5th. And again, if it can be filed sooner, I highly encourage it. All right. Counsel, I'll need you in the building there in Howard, checked in through any security, and be ready. I'll ask that Mr. Walker, Mr. Pate, Ms. Gillett, I'll be there by 8:45 a.m. that first morning. If there's any other last minute matters that we need to talk about, we'll have the opportunity to do so before our scheduled start time at 9:00 a.m., which I'd like to get started promptly, if at all possible. All right. Thank you all for your time and input to the court this morning. Mr. Walker, this court does have certain dress code expectations for participants during a jury trial. Mr. Pate's a very experienced attorney and handled many jury trial situations. If you have any questions about what's the proper thing to wear, just ask him. And I'm sure whatever advice he gives will be sound and you will follow it. All right.
Yeah, the whole
If
dress
there's
code
nothing
thing
further
had-
at this
had
time,
several of us confused.
the Robert Walker Jr. matter will currently be in recess, and this meeting may be ended for all at this time.
Yeah. And look at Jill. I mean, look at how she ended that out there.
Yep.
Got those face. I bet she's got tears under there because this was a rough hearing.
Oh, and you know she's looking to blame anybody and everybody for her mistakes there. She's probably like, those two guys from fucking
Oh, sure.
Douglas County, they causing all this shit for me. You know she's
Right.
doing that shit.
And now that we've done this,
instead of looking in the mirror and saying, oh, you know what, I dropped the fucking ball on that big time. On every one of those things, I dropped the fucking ball.
Yep. And she you guys all need to go subscribe to Dick's channel. He's the one that broke this. He's the one that sent it over to me and said, hey, you got to look at what happened with this guy. I found out here recently that Robert had tried to reach out to me several months ago, and it didn't make it to my radar for some reason. I didn't catch it or I didn't see the message. But that's the thing about these kind of alliances that we have with different channels, and the cooperative nature of this work is that when one of us gets an eye on it, we start passing it around and say, hey, did you see this? Did you see this? Next thing you know, somebody's going to grab hold of it. You know, it may not be the first person you talk to, but it's definitely going to come. But
yeah, and another reason to go over and subscribe to Kansas Freedom News is that he's breaking stuff in Jackson County as well, which is where me and Michael have been going as well. And Kansas Freedom News was shining light on First Amendment rights violation that happened at the county commission meeting there as well. So Dick, as far as I know, has at Kansas Freedom News has broken both those stories. So it's important to, and what I mean by breaking it is, I mean, just shining light on it that got people's attention to want to look at it a little bit further and bring even more attention to it. So if you go over and subscribe to his channel, you'll get the Elk County content, and there's which is ongoing, and then of course there's this developing Jackson County stuff that's going on there that's pretty dang interesting as well. So you can go over there and check that out.
Yep. And look there, Firm says he might be trying to come out here on the 6th to go watch the hearings. The only thing I want to say, guys, is we are a community out here, and we do need to represent this properly and not interrupt this court hearing. So if anybody does come down here and comes to Howard, Kansas to go to this hearing, and it's on the 6th, 7th, and 8th, it's what's it's scheduled for, you know, you guys need to, you're going to affect Robert. If you start acting out, Jill will use that to try to put a fire on him, because she knows she can't get to many of us that are out here doing this work and aren't afraid of things. So if you guys come down here, be respectful of that, and the fact that Robert will suffer for any outbursts or any problems that you create here. So come down, be respectful, watch the hearings, and let's participate in some discussion afterwards. I mean, I'd be happy to go live with some of you after each day's hearing and discuss it. That would be awesome.
Yeah. And not to say that anybody would intentionally go and do that, but sometimes we don't know the rules. And for these court hearings, we're just observers. No talking at all. You can't disrupt it at all. There's no reason to be talking. And also, you know, there's no recording inside there either. So it's important to follow. It's important to follow those rules and be respectful of those rules, because this court is a very important thing.
Well, and when you're in there, guys, there is no, I mean, you interrupt the court, there's no process of warnings or anything. You can be held in contempt and jailed. And I think, what is it, up to 30 to 90 days, 180 days? Is that the contempt max is 180?
I'm not sure.
I'm not sure, but it's longer than you're going to want to spend in jail for being a dumbass in court.
Yeah. Yeah.
So
just come watch if you're going to watch, and then we can talk about it after the court and stuff like that if you got something to say.
All right, guys. And again, this is next week. We've been following it all along, and the only reason we started following it was because it looked like they were going to literally railroad this guy. And now that he's got an attorney who's actually fighting for him, that's a little bit of the reason you haven't seen us down in Elk County so much, because he got representation. He got the scale balanced a little bit so that he could actually get a fair hearing. And that was our biggest concern, was just making sure he could get a fair hearing with all that was going on down there. So we're happy that all this is turning out the way it is. Whatever the verdict is next week, at least I think I can feel comfortable that he's at least got the right kind of representation to be able to argue the case.
Oh yeah, a lot better position than if House was still represented.
Exactly.
No doubt about it.
Exactly. And definitely not something you want to try to do pro se, even with an idiot like Jill. What they say, an attorney has a fool, an attorney who has himself as a client has a what is it? A man who tries to act like his own attorney has a fool for a client. Is that how they say that?
Yeah, I think that's close. Yeah. And it's true.
Yep.
It's true. It's true.
Yeah. All right. Any last messages?
Nope, I don't believe so. Just appreciate everyone that's tuned in and watching and participating and is interested in this case here.
Yep. All right, guys. Thank you. We're going to go ahead and sign off here. We appreciate y'all coming out and watching. And again, thanks for your support of everything that's going on and everything that we're into. So have a good night, all.
You can't win.
You can't say whatever you want and then face some sort of repercussions for it later.
Hey, fun, son. Nothing else in the world smells like that.
Kansas has possibly the weakest open records law in the country.
Retaliatory animus, had it not been for that negative feeling towards speech, they would have not done that.
You think you can still control my life, control never yours to take.
Are you telling me that 200 men against your boy is a no-win situation for us?
Wishing you could see things was my way, when it all gets ripped away.
I love the smell of napalm in the morning.
I can't hide